am Leon Smith. I'm an associate at DAC Beechcroft. I specialise in construction, engineering and technology-based disputes, and I'm also a council member for Bristol Law Society. It is my pleasure today to introduce our latest lunchtime learning webinar with an update on data protection law. Hopefully, you should all be receiving the email slides out as a PDF following today's talk. If you do have any questions, then please do add these to the Q&A box on Zoom, and we will try to pick these up at the end. Please also note that the presentation is being recorded today, so do be mindful of your own data security and don't ask any questions that you don't want to see being answered on YouTube by the end of the week. Our guest speaker today is Andrew Gallie. He's a partner at VWV, specializing in data protection and information law, including information security, privacy, CCTV, and subject access and freedom of information requests. He will be speaking to us today on key data protection risks and various latest developments and how they will impact on compliance, including managing those tricky subject access requests, information security and data breaches, and an update on data protection and digital information bill, and other developments, including new ICO guidance on employment and marketing. Thank you for joining us, Andrew.
Thanks very much, Leon. Welcome everyone to this data protection update. So, as Leon mentioned, it's really a mixture of recent developments, and also I want to cover off what I think are the perennial high-risk areas around data protection, so information security, and so on. It's always good to have questions, so I hope to finish a bit early, so there should be some time at the end for questions, which would be great. So in terms of what I'm going to cover off today, I'm going to start off by looking at subject access requests. I'll then look at some other compliance topics. The ICO has been busy producing new guidance on a variety of topics, so I'll look at that as well. There's also been some developments around data protection reforms, so the new data reform bill, we'll see where that's got to. Then I'll finish off just with some thoughts on information security and some key takeaways from recent data protection litigation. Okay, but before we dive into that, I just want to have a very brief reminder of what we mean when we talk about data protection law. So data protection law really consists of three things. You've got the UK GDPR, which sets out most of the rules, the things that you have to comply with. So the obligation to comply with data protection principles, people's data subject rights, are all found in the UK GDPR. That's supplemented by the Data Protection Act, which contains most of the exemptions from disclosure. So if you're looking to withhold information under subject access request, you may be able to find what you need in the Data Protection Act. And then find that the third piece of the jigsaw, the privacy regulations, which cover things such as the rules around electronic marketing, and also rules around setting website cookies and similar things. So that's so really when we talk about data protection law, we're talking about those three things, but these days it can't really be seen in isolation. So you've got sort of a wider privacy compliance framework these days. So you've got sort of thoughts such as misuse of private information, breach of confidence, and also, as this is a law firm themed topic, there are also SRA obligations to think about as well, and we'll be looking at a couple of examples later on. Okay. So subject access requests. I would say that probably most of the work that we do relates to helping clients deal with difficult subject access requests. So this is the right that an individual has to request a copy of their personal data, and they can be quite problematic to deal with them in practice. So anyone can make a request. You get a request from an employee, for example, or a client. And I suppose my first point really is that you should sort of have a strategy right from the outset, because SARs are never ever made in isolation. No one ever makes an SAR to find out how good you are. It's usually made because somebody is thinking of bringing a complaint or a grievance, or there's even litigation pending. So think about your strategy. So on the one hand, sometimes it pays to adopt a really transparent approach and sort of disclose as much as you reasonably can to sort of demonstrate that there's nothing to hide. But equally, there may be times when you sort of want to withhold as much as you lawfully can because you're concerned that something might sort of fuel a further complaint or litigation. So have strategy in mind, and there is quite a lot of flexibility in the exemption. So you can often sort of come to the conclusion that you want within the framework of the legislation and the exemptions. Excuse me. So you're also entitled to ask for clarification if you process a lot of information about somebody. And this might be particularly relevant. Let's say you've got an employee who's worked with you for, say, 20 years, and they make an SAR and they want, quote, all the information you hold about me. In these circumstances, you're entitled to go back to the requester and ask them to be a bit more specific. For example, does the request relate to a particular incident? Does it relate to a particular colleague, or is there a particular date range? Now, if the individual insists that they want absolutely everything, then you've got to respect that, and you've got to carry out a reasonable and proportionate search. But to be clear, that does not mean you have to search under every single sort of nook and cranny on the off chance that it might conceivably contain disclosable personal data. So keep your searches proportionate. So you've got 1 calendar month to respond, but you can extend that by a further 2 months if the request is complex. And complexity, whether a request is complex or not, very much depends on the circumstances. So, for example, if you're sort of having to sort of apply exemptions to a large amount of very sensitive data, then arguably that's a factor that might make the request complex. Equally, you can take into account your own resources when deciding what's complex. So a request may be complex for one organisation, but not for another. Now, we've been advising on these things since GDPR came in 2018, and we have never ever had a situation where the ICO has challenged a decision of one of our clients to claim that a request was complex. So in the eyes of the ICO, in the eyes of the regulator, it seems to be quite a low bar before we can claim a request as complex. That might partly be because, as I'm sure many of you will know, the ICO are very under-resourced, and they and chances are, if somebody complains to them that the control is going to take 3 months rather than 1 month to respond, by the time they actually look at it, the ICO, then the request would have been sort of dealt with. They set a new record with me a couple of weeks ago. I made a data breach report on behalf of the client last April, and I finally got a response a couple of weeks ago confirming that they weren't taking any action. So that perhaps just shows sort of don't always expect a quick response if you interact with the ICO. Okay. So once you're sort of clear on strategy and approach, and you've thought about whether you want to go back to the requester, the second step is to be thinking about sort of locating the personal data. What sort of searches do you have to undertake? And as I mentioned, the obligation is to carry out a reasonable and proportionate search. So that does not mean spending sort of 5,000 hours searching every single email that's ever been generated on the off chance it contains something disclosable about the person who has made the request. And so clearly you should be searching those locations on your systems where you think there may be disclosable information held. You should also perhaps be discussing the request with those individuals who you think might hold disclosable information as well. Quite often, people carry out keyword searches when responding to it and when searching for information, and often requesters will sort of set out in their request the sorts of information that they'll sort of ask that certain keyword searches are made. But there's no legal obligation to do keyword searches, and there's no legal obligation to sort of to carry out the exact search parameters that the requester has requested. So if, for example, you receive an SAR from John Smith, and he asks you to search keywords John and Smith, then you're probably on strong grounds to resist doing that. Possibly the area where I sort of maybe see sort of controls fall down most is just something actually on the definition of personal data. So what actually is personal data? And in relation to SARs, I find people will often disclose far more information than they actually need to. And I think a lot of the problem sort of comes down to what is and isn't personal data. So personal data is information that relates to someone and identifies them either directly or indirectly. So if we take employees, for example, everyone, myself, we all generate, sort of hundreds of emails, documents every week as part of our job. We will be copied into correspondence. If someone makes an SIR, if an employee makes an SIR, the vast majority of information that has their name on it or that they've created just won't be disclosable, and that's because it's not really about them. It is more them sort of acting in the course of their duties as an employee. It might only become their personal data if, for example, an email, some advice to a client was used in connection with a process about that employee. For example, if the client raised a concern and it was used as part of a capability process in relation to individual. So the vast majority, in many cases, the vast majority of documents that you hold that has someone's name on, you just won't need to consider. This also relates to a second point, which is that the obligation is to supply the personal data rather than documents. There's no right to documents under a sort of access request. And what that means is that it's perfectly lawful to copy and paste personal data from a document and say put it into a table. And often that's the appropriate thing to do if, for example, there's lots of relevant information about other people or commercially sensitive information in the document itself. I also just make sure that you store information in the appropriate location. So if you receive an SAI, you know which locations to search. You have sort of good record keeping practices. You're not sort of scrambling around trying to work out where the information might be held. Excuse me. Another issue which sometimes crops up is the extent to which there's an obligation to search personal devices and personal platforms, so personal email accounts, for example, for information in response to sort of an access request. And the answer is that you don't need to sort of be searching personal platforms unless you've got a good reason to suspect that they hold something disclosable. But I think it's just really important to make sure that you've got sort of policy or policies and training make it very, very clear what the rules are. And obviously that's something you'll be doing anyway as part of your SRA obligations and just the importance of keeping client data confidential. Okay. So about the exemptions, so we've carried out searches and we have sort of a big bundle of information that we now have to think about whether or not we need to share this. So I've just set out on the slide here some of the exemptions that we frequently rely on. One of those popular is what we call the mixed personal data exemption. And so this applies where information is both about the requester and about someone else. So for example, if there was an email from, say, a colleague sort of spreading gossip about somebody and they made an SIR, that would be personal data information both about the person who wrote the gossip and the subject of the gossip. So what do you do then if you've got sort of information that's mixed data both about the requester and a third party? And you can withhold the information, you only have to disclose the information if the third party has consented or it's reasonable to disclose in the absence of consent. And there's no legal obligation to seek consent. And sometimes doing so wouldn't be appropriate, for example, as part of a confidential HR process. So often it's a question of balancing the requester's right to the information against the right of the third party. And you have quite a wide discretion here about what to do. Essentially, as long as your conclusion about whether or not the information can be shared won't sort of be overturned by the ICO or by the courts, so long as what you've done is within the range of what is reasonable. There's also case law to suggest that in the balancing exercise, you can also take account of commercial interests. So if you think that if it's mixed personal data and you're concerned that that disclosure would sort of prejudice the firm's wider interests, then that's potentially a factor that you can take into account too. There are also similar exemptions for negotiations and management planning. So the negotiations exemption covers personal data that consists of records of intentions of the controller in relation to any negotiations with the data subject, to the extent that the application of those provisions would likely to prejudice those negotiations. So let's say, for example, you are negotiating a settlement agreement with an employee. There might be some internal emails that are setting out what you might be prepared to offer the employee by way of a settlement, so like a best case, middle case, worst case scenario. It would clearly be a complete nonsense if the employee could make a sort of access request to get a copy of that email. So in those circumstances, you'd be able to withhold it. There's also an exemption for management planning, which covers personal data processed for the purposes of management forecasting and management planning in relation to business or other activity, to the extent that the application of those provisions would relate to prejudice the conduct of the business or activity concerned. So if, for example, you're going through a restructure, or you're sort of thinking about pay rises or promotions, if somebody makes an SAR to find out what's happening to them, you can often withhold disclosing anything until the date of the official announcement under this exemption. Happily, information caught by legal professional privilege is also exempt from disclosure under sort of access request. But interestingly, the exemption in the DPA and the Data Protection Act goes further. It also covers information in respect of which a duty of confidentiality is owed by a professional legal advisor to a client of the advisor. And that has a couple of implications. First, if a privilege has sort of accidentally been waived in something, that doesn't necessarily mean it then has to be disclosed under an SAR. But arguably, it also means that there is a potential that you could sort of run the legal privilege exemption in connection with giving advice that's not legal advice. So, if, for example, your practice that provides HR consultancy services. So there's some interesting points there around the application and scope of the exemptions. I'd also suggest, as ever with these things, don't take a blanket approach. Think about the exemptions carefully. And as I mentioned at the start of this session, of this particular topic, if it's something that you're really concerned about, it's often possible to find an exemption to lawfully withhold it. So if you do have a tricky SAR, we would always be pleased to assist. And then finally in this section, can we ever refuse to respond to a subject access request? The answer is yes, in limited circumstances. We can do so if the request is manifestly unfounded or manifestly excessive. And really, this sort of look at the core of this is if the request is so unreasonable that we can refuse. I've only sort of relied on these points sparingly. For example, we had a situation a couple of years ago where an employer of the client was making defamatory comments, really unreasonable, really horrible comments about colleagues on social media. And it seemed clear that they made an SAR, and it seemed clear that they were just doing so to sort of to get extra material with which to make further defamatory comments. And we suggested that the request was manifestly unfounded, and happily the ICO agreed with that position. Another example, we got involved at quite a late stage where again, as part of an employment dispute, an employee was sort of making a new SAR, sort of like clockwork on the 1st of every month. And it seemed that it sort of had no interest into the data, that it was just sort of part of their sort of siege warfare approach to the wider dispute. the client went down the ran the manifestly excessive argument on the basis that it was just the same request over and over again for the same data. Okay, so if you do sort of if you do refuse to deal with the request, then you just got to sort of let the person know about the right to complain to the Information Commissioner and the right to bring a court claim. Sometimes letting people know about the right to complain to the ICO isn't a bad thing, and that's because you can sort of make it the ICO's problem for a while, and rather than yours. And certainly in my experience, the ICO are quite a sympathetic regulator. So if they feel that the request has been unreasonable, you comply with your obligations, then then they're not going to sort of to waste too much of your time. Okay. So I'm not going to cover off just some of the other compliance topics we've been advising on recently. Privacy notices. So under UK GDPR, you've got to, as part of your transparency obligations, you've got to provide people with certain information about how you use their personal data, for example, who you share it with, what you use it for, and so on. And this information is usually found in a privacy notice. So you should all have privacy notices covering your staff, and also external ones covering clients and so on. So I've just make sure it's surprising the number of sort of bad privacy notices there are out there, and it's kind of such an easy thing to get right. So just sort of make sure that you're sort of comfortable and confident around your privacy notices. They can also be really helpful if you're dealing with a data protection related complaint. For example, a data protection complaint is often framed in terms of you had no right to share my data, or you had no right to use my data for this purpose. And if you can point to where it's covered off in the privacy notice, then that's really helpful, because it can help to build a case that it was lawful, it was transparent, and that you were sort of clear with the requester, with the complainant, how their data was used and so on. There's also an obligation under a subject access request. So you've under an SAR, you don't just have to provide a copy of the personal data they've requested. You've got to provide certain ancillary information, for example, information about the right to go to the ICO, sources, recipients, and so on. But the information you have to provide under an SAR, this extra information is pretty similar to the information that you need to provide in a privacy notice. So sort of rather than sort of listing in the cover letter in an SAR all these sort of bits and pieces, it's often just more convenient to simply include a copy of the privacy notice, which should contain all of the extra information that you are required to share. Okay, so data protection and outsourcing, and this is, I mean, in terms of the sort of the work that I do for our firm's own compliance, this is probably the area where I get most involved in. So law firms, as with any other sector, are sort of outsourcing more and more. We're sort of trusting more and more third parties, suppliers, with our sort of our clients and our employee personal data. And so we should just be thinking about data protection and confidentiality when doing so. So just going back to absolute basics for a moment, everyone who processes personal data or has got responsibility for personal data will either be a controller or a processor. And a controller is the entity that decides, that makes the important key decisions about how data is used, for example, what data to collect and for what purposes to use it. A processor, on the other hand, can simply process personal data on the instructions of their controller. So it's really important when thinking about outsourcing, just be thinking about, is this supplier, are they a controller or a processor? Because what you have to do will sort of flow from that. And I would say in the vast majority of cases, the supplier is going to be a processor, because all they will be doing will be holding your data on your instructions. So this might apply if it's a payroll service, for example, a virtual deal room, most IT services, sort of managed office services as well. So usually, but not always, they will be a processor. Just to give an example where there might be a controller, if you sort of outsource your entire HR function, that might make them a controller, because they'll sort of be making sort of key decisions about HR matters. They'll sort of be using their expertise, their professional discretion to decide how to sort of run with HR matters, but equally they could be both a controller or a processor, different processing. So if you engage a processor, you need to do two things. You need to make sure that your contract with the processor contains the wording mandated by Article 28 of the UK GDPR, which contains some quite specific requirements around things like data security, audit rights, and confidentiality. So just make sure that those obligations have found their way into the contract. But it's not enough to simply have the contract and forget about it. You've also got to only choose processors who provide sufficient guarantees around compliance. And in practice, that will sort of involve a degree of due diligence on the processor's compliance. So just be thinking about, I would suggest you focus on data security in particular. Excuse me, so sorts of questions you might ask, you might be checking is sort of whether the data held, is the data encrypted during transit and at rest up to a state-of-the-art standard? Are they certified to a recognized information security standard? Most suppliers should have documentation that will sort of preemptively answer all your questions. So just sort of ask for a copy of that, and also be liaising with your IT colleagues as well, because it's both a legal and a sort of a technical practical point as well. The SRA code requires solicitors just to provide access to gives the SRA extensive rights of access to information. So it's important that your agreements with your suppliers contain the appropriate rights of the firm, and also the SRA to sort of audit and get information from the processors as well. So just make sure that sort of SRA disclosure is covered off, and that the contractor will be required to provide information when requested. Okay, so I'm now going to move on and talk about recent developments and what's on the horizon. So the ICO have been really busy. They've produced a lot of guidance in the second half of last year, and I think they're being pulled into different directions. So on the one hand, as we'll come on to with the new data reform bill, there's a real sort of emphasis on making data protection law a bit more digestible for businesses, a bit less of the burden. And so I think the guidance on international transfers, for example, reflects a bit more of a light touch approach, but equally that's kind of mindful that sort of new technologies, new ways of working, and new practices are sort of increasing the risks, which I think is reflected more in their updated employment practices guidance, which take a bit more of a sort of a pro-data subject approach. So the ICO's employment practices guidance has been around for many, many years, but it's now in the process of being updated. So before Christmas, the ICO produced draft guidance on staff monitoring and draft guidance on health data, and there'll be further guidance to follow during the course of this year. But the ICO also finally produced their long-awaited guidance on international data transfers and carrying the transfer risk assessment. We could spend sort of, a whole day talking about international data transfers, but I just want to cover them off briefly. Going back to basics for a moment, you can only transfer personal data to a controller or a processor outside of the UK if one of three conditions applies. Either the destination country has an adequacy finding, there's a safeguard in place, such as using the standard data protection clauses that the ICO have produced, or third, if an exemption applies. In practice, in many cases, if there's no adequacy finding, you'll be relying on a safeguard, and that safeguard will usually be the standard contractual clauses. So it's a question of incorporating those into the contract or signing them as a separate agreement as appropriate. Until quite recently, the standard clauses available consisted of these ancient EU standard contractual clauses, which have been around for long since before GDPR. But the ICO produced two new sets of clauses early last year. First, you've got the IDTA, or the International Data Transfer Agreement, which is a standalone contract for international transfers, but they've also produced an addendum, which is intended to sit alongside the new EU SCCs. So that sort of enables you to use the EU document, but sort of make it compliant from a UK perspective. We've spent a long time sort of talking about which one's best. Should we use the IDTA? Should we use the addendum? In very broad terms, I think the addendum is probably more flexible. It's just kind of easier to work with, but it's expressed in language that I think is perhaps more onerous, and the IDTA reflects a slightly more light touch approach to these things. Following the Schrems 2 case, which I'm sure many of you will be familiar with, this happened whilst we were still subject to EU law. The European courts found that it wasn't sufficient to simply rely on the standard clauses by themselves, and as an additional step, you need to risk assess the transfer. And so the ICO finally produced its final transfer risk assessment tool in November last year. So if you're sort of transferring data overseas, if you say you're using a supplier based in America, then you will need to go through the transfer risk assessment process in addition to using standards, the data protection clauses. As I touched on a moment ago, there's a bit of a drive government level to make data protection a bit less of a burden. And as part of that, the government's looking very closely at issuing additional adequacy findings so that we don't have to worry about these things when transferring data. And I fully expect that there will be an adequacy finding for transfers to the USA before too long. So hopefully we won't have to worry about sort of standard clauses when transferring personal data to the States. Okay. So as many of you will be aware, the Data Protection and Digital Information Bill was published last summer, and this was set to reform data protection law. And it was, it was looking to reform all aspects of the law, so both the GDPR, the Data Protection Act, and the privacy regulations. And what was kind of underpinning it was a desire to sort of make things a bit easier, reduce the data protection red tape, and so on. So the bill it's had a bit of a difficult birth. It was pulled it was scrapped as one of the first acts of the Truss administration last September, who apparently felt it didn't go far enough and sort of wanted to sort of scrap GDPR lock, stock and barrel. But the latest is that it will reappear in some form, but probably in a sort of with some further amendments to make it sort of even more light touch. So expect the bill to appear at some point this year. So because things are a bit up in the air, I'm not going to spend too long looking in detail at what the bill says. So I just want to sort of pick up on a couple of key things that might be relevant to the law firms. So as things under the current rules, under the UK GDPR, many organisations have to appoint a DPO or a data protection officer. The DPO role is going to be scrapped and replaced with a obligation to have a senior responsible individual for data protection compliance. Now, I doubt this was the intention, but certainly on my reading of this, it appears that a lot of organisations that weren't caught by the DPO requirement will need to have an SRI. And I think in particular, most law firms don't need a DPO, but I certainly think most law firms will need to have an SRI. So this is just something to be keeping an eye on. So the SRI must be a part of the organization's senior management, and senior management means individuals who play significant roles in the making of decisions about how the whole or a substantial part of its activities are managed or organized. So you have to think this quite carefully about who your SRI will be. And it won't necessarily relate to sort of job title. I think it's a question of fact: is the individual involved in a whole or a substantial part of the business's activities? So it's something to be aware of. There's also going to be, again, if the bill goes through in its current form, there's also going to be a more structured approach to dealing with data protection complaints. So organizations will be required to have a complaints policy, a data protection complaints policy. I don't think this is going to make much difference in practice. I mean, really, this is about making it slightly more difficult for complainants to complain to the ICO. So really, it's about protecting the ICO, so they've got some more sort of hoops to jump through before they can bother the ICO with their complaint. There's also going to be some changes to the documentation requirements. So one of the perceived problems with data protection law is that it creates a huge amount of work in terms of having documentation in place, need privacy notices, policies, procedures, Article 30 record, appropriate policy document. And so it's looking at sort of cutting out some of the documentation requirements. So, for example, the obligation to carry out a data protection impact assessment is going to be replaced with something a bit shorter, but I would just query what difference it'll make in practice. So the obligation to do an EPIA is tentatively going to be replaced by an obligation to carry out an assessment of high-risk processing, but in practice it seems not very different. So you can include slightly less detail in the assessment, but it's kind of it's pretty similar to what went before. Perhaps what's more helpful is that there's going to be further steps to sort of to clip the wings of people who are perhaps who are thinking of making unreasonable SARs. So there's going to be potentially a new exemption for vexatious SARs. And one of the criteria that might point to a request being excessive is if the request is an abuse of process. So if you're sort of if someone's bringing a claim against you and they make an SAR, as is sometimes done, to get disclosure ahead of or outside of the litigation process, then arguably that's an abuse of process because they're entitled to get the information that's relevant to the dispute as part of litigation disclosure. But these things really depend entirely on how the ICO and how the courts interpret them. Because if it goes through its current form, it can make no difference, or equally, it could be quite a change. So it'd be interesting to see how that develops. Okay, so finally then, I'm just going to cover off some thoughts on information security and data breaches. So if we go back to essential principles for a moment, the data security is one of the 7 principles in the GDPR, and controllers and processors have to put in place appropriate technical and organizational measures to safeguard personal data. Technical measures are things like network security, using encryption and so on. Organizational measures are about sort of the policies, training and procedures. And if you could just sort of, if there was just one area of data protection compliance you get right, it's this. And that's because the vast majority of ICO enforcement action and of data breach claims arise from security breaches. So it's important to get right. And I think it's quite interesting that the GDPR and Data Protection Act, they runs over 1,000 pages, but there's only there's less than a side of A4 covering data security, which is perhaps slightly surprising given how how important it is. The GDPR unpacks these requirements slightly. So you've got to have in place what's appropriate encryption and pseudonymization. You've got to keep data confidential, preserve its integrity. It's got to be available. So if you have data on a memory stick, it's encrypted, you forget the password, That is an availability breach, even if the data doesn't end up in the wrong hands. And there are also requirements around carrying out backups, so like penetration testing, so backing up the data, testing as well. So if the GDPR is light on detail in terms of what you should be doing in practice, there are lots of resources out there. I would suggest that your sort of colleagues with sort of focused on cybersecurity should be looking at the National Cybersecurity Centre website. So the NCSC is a government body. It was set up about 10 years ago, sort of to improve the UK's cyber resilience and to provide advice and guidance to UK organisations. And they've got a huge amount of resources around cybersecurity. So it's well worth sort of looking at in detail. It's also very noteworthy that whenever the ICO is sort of looking at enforcement action, it will scrutinise what the organisation did very carefully against NCSC standards. And it's far more likely to sort of make an adverse finding if it considers that the organisation's security wasn't up to the standards as set out in the NCSC guidance. So it's a helpful resource. Excuse me. So I've set out on the slide here some examples. I'm sure we're all familiar with these, or things go wrong. So sending emails to the wrong recipient or email addresses being visible to everyone. This is if I had to categorize, if I sort of add out all the different types of data breach that we've advised on, this would come out top because these things seem to happen all the time. It's just too easy to make a mistake. You can get software that sort of prompts people to sort of check that they really want to use that email address. Do they definitely want to send it? Yes, no. So there are things we can do to mitigate the risks here. We also do a lot of work around ransomware attacks, so phishing emails and so on. So if you receive it, someone receives an email, they click on the link and it encrypts the data. So again, just be thinking about sort of making sure that you're sort of guarded against these sorts of attacks. One of the things that we do here at VWV is our IT team like to send out fake phishing emails to everybody to see if they sort of fall for it. And one of the most popular things they do is if we have a new starter, they will send out a LinkedIn connection request, apparently from that new starter to everyone, sort of inviting the recipient to connect with the new starter on LinkedIn. And if you click on the link, then you get a sort of a telling off from IT. And what you should do instead is you should sort of connect with people through the platform on the web or on the app, rather than sort of clicking on the link in the email, even if it looks legit. And these sorts of tests, not only are they really good at sort of actually checking what the level of compliance is, but they'll also sort of just help people think about compliance, help people sort of make sure that people are mindful of the risks. And also, if something does go wrong, it's also good evidence as part of your case with the ICO that you did take appropriate steps to look after personal data and to test compliance. Just before Christmas, the ICO announced a 4.4 million fine against Interserve, the construction company. And the ICO found that they were lacking in a number of areas. So what happened with Interserve was they received a phishing email, it got forwarded on to someone else within the organization. They clicked on the link. The antivirus software that they had picked up part of it, but there was still some malware on the system. But what was interesting was if you look at where Interserve fell down, it's exactly the same issues that sort of occur again and again and again in different sectors. So really, it's about getting the basics right. For example, one of the Interserve staff members involved didn't have training on cybersecurity. They were using out-of-date and unpatched software. So these are all things that just seem to crop up again and again. So in terms of the consequences of getting data protection law wrong, worst case scenario, you can have a fine of up to £17.5 million or 4% of worldwide turnover. The ICO can also take action short of a fine. For example, there's often an element of naming and shaming. So if a breach has happened, but the ICO doesn't quite think it meets the threshold for a fine, they might still sort of publish an enforcement action or what they did on their website. And dealing with data breaches take up a lot of time and effort and can be really, really exhausting. And so, they just sort of, they can just sort of consume stuff, for weeks. So, it's just it's sort of a nightmare from a resource point of view. And there's also a risk of compensation claims. Okay, so 10-15 years ago, sort of compensation claims and data protection wasn't really a big thing. And that was in part because to bring a claim under the old Data Protection Act, you had to show financial loss, and you couldn't, for example, claim for distress unless you could demonstrate a financial loss as well. But then over the past few years, there's been a sort of a gradual eroding of that position, where it's got sort of easier and easier for people to bring claims. So at one point, for example, the court decided that you could actually bring a claim under the Data Protection Act for distress alone. And perhaps the high noon of this from a claimant point of view was a few years ago, where the Court of Appeal suggested that you could claim compensation for a data breach for loss of control. But in the past 18 months or so, the pendulum has swung much back more in favour of the organisations, I think, of the controls and processes, and the environment has become slightly less claim friendly. So we had the Supreme Court case in Lloyd and Google, which dealt with a number of issues, but for our purposes, it confirmed that somebody couldn't claim compensation for data protection breach for loss of control only, and there had to be some degree of damage or distress, which was really helpful, because it almost seemed we were getting to the point where if somebody was the victim of a technical data breach, they could bring a claim even if they'd suffered no loss, which would clearly sort of open the floodgates to all sorts of claims from the litigious data subjects. Now, Lloyd and Google was decided under the old Data Protection Act, but it seems likely that the same principles will be applied under the UK GDPR, even if the position isn't quite certain, but it seems likely that it will be followed. So there was more recently, there was a case actually involving this firm, Rolf and VWV. So this was a claim by the Rolf family against us. It was possibly that the first reported decision that sort of showed that damages are not available when no credible harm can be shown. And what happened here was that an email went from us to a debtor. There was a typo in one of the email addresses, the result that it went to the wrong person, and the unintended recipient confirmed that they had deleted the email promptly, and so it was also contained. But nevertheless, there was a claim made against us. We were successful in getting the claim struck out. And I'll just read a quote, if I may, from Master MacLeod, who said that in the modern world, it is not appropriate for a party to claim, especially in the High Court, for breaches of this sort, which are frankly trivial. She said the claim was plainly exaggerated, with a frankly inherently implausible suggestion that the minimal breach caused significant distress and worry and even made them feel ill. In my judgment, no person of ordinary fortitude would reasonably suffer the distress claimed arising in these circumstances in the 21st century. So what this demonstrates is that the courts are kind of, won't really sort of accept people sort of trying their luck with sort of bringing sort of spurious or exaggerated claims. So I think that was a good result for organisations who handle data. Okay, so nevertheless, having said all that, it's obviously far better to get it right first time around rather than sort of have a breach. So as I've been thinking about sort of your policies, your data protection training, and just making sure that your systems are secure as well. And it's also worth noting that the obligation under data protection law isn't to sort of to prevent things from going wrong. It is to take appropriate steps. So in some circumstances, it'd be quite possible to argue that even if a breach happened in the ordinary sense of the word, that it wasn't actually a data breach because it happened notwithstanding the training, the policies, and everything else that you had put in place to safeguard personal data. Okay, so that was everything I wanted to cover off. Leon, do we have any questions from the audience? I'd be happy to answer.
Yes, indeed. Thank you very much. Andrew, just having a look at some of the things that have come in on our Q&A. There's actually a few questions. First question is the UK likely to adopt any decision agreed between the EU and the US on the exchange of personal information, please?
I expect that we will get we will shortly find that the US are adequate. As to whether we will piggyback on the EU decision or go our own way, I don't know, but there's a real drive to make international transfers as flexible and as easy as possible. So I don't think there'll be any problem with getting adequacy in one form or another.
Thank you very much. Another question, if a serious breach of GDPR leaves someone's data exposed and they suffer distress, how do you value that distress? i.e., is there a table or are there any guidelines recognised by the courts that identify different types of data breach, the seriousness to the victim, and the likely range of damages one would expect the victim to be awarded for such breach?
So there's nothing prescriptive. It very much depends on the specific circumstances, and one of the problems is actually being able to quantify the level of damages. At one end of the scale, I mean, I think most claims are pretty low, to be honest. So if you're probably looking at less than £1,000, unless there's something actually properly material or sensitive. There was a recent case, Driver and CPS, where an absolute minimum amount of data had been disclosed, and they were awarded £250. But that was the court made it clear that was that was at the absolute bottom end of the scale. But if it's really, I think if it's really serious, then you're looking in these tens of thousands. But most sums are pretty low, to be honest. Just talking hundreds, or possibly low thousands.
Thank you very much. Another question. ICO guidance on what amounts to personal data breach seems to be very wide. Breach of security impacting on confidentiality, integrity, or availability, and doesn't require disclosure. Should all integrity incidents be considered breaches? I'm thinking of recording an address incorrectly or sending a letter to a named person to an incorrect or previous address.
You're absolutely right. So an integrity or an availability breach can be a personal data breach. And it really just does depend on the circumstances. So if you send a letter to the wrong address, then I think you just have to think about what actually was in the letter. How what actually happened? Was it returned? If the letter was returned unopened, I don't think that would require reporting to the ICO. But equally, if those things are quite sensitive, then you may need to consider reporting. The ICO have been at pains to emphasise that they get far more breach reports than they think meet the threshold, and they kind of try and encourage organisations, to perhaps think quite carefully about whether or not the incident does meet the threshold for reporting. Another reason why it might be worth being slightly reticent about reporting is and this is kind of slipped in under the radar. The ICO now publish, it seems, every single data incident that's been reported to them. So they have a spreadsheet and it lists tens of thousands of organisations. It's not sort of widely published on the ICO's website, but it is there. And so if you do report a breach to the ICO, then you will quite possibly appear on that list.
Thank you. In respect of subject access requests, is the requester legally obligated to disclose the reason for an SAR? If not, how do you determine if a request is manifestly unfounded? Could you please give some examples of a manifestly unfounded SAR? Yeah,
sure. So it's one of the situations where the law and the guidance says that it's purpose blind, and it kind of is, but it's not. In particular, when deciding whether a request is manifestly unfounded or manifestly excessive, then possibly motivation is relevant. As I mentioned, the occasions when I've relied on this on manifestly unfounded, this was an individual who had sort of had a campaign against their employer and certain individuals, and they were publishing all sorts of really quite nasty and quite defamatory comments about colleagues on social media. And it seemed from the circumstances that the only purpose of making the SAR was to gain extra material to sort of publish online and to try and sort of further humiliate this person's colleagues. Another example given by the ICO is where if somebody makes an SAR but then demands money to withdraw it, because in that situation it's clearly not the case that they have any real interest in getting their personal data. They're just trying to do it to get money from you.
Thank you. Someone else has asked, what happens if a DSAR asks for messages sent between people on, for example, WhatsApp? Do we have to check these, in particular, if the app is on an employee's personal device?
That's a good question. So if it is a work organized WhatsApp group, then yes, absolutely, it's within the scope of the request, the same way it would be if it was your work email system. If it's not, so if it's an exchange between two employees on a private WhatsApp group, you only sort of have to to think about private WhatsApp groups, private emails, if you have good reason to believe that they hold disclosable data. And so you shouldn't sort of be actively sort of asking staff to hand over their personal phones and so on. So it's only if you sort of on notice that there's a good reason why that might be the case. But in those sorts of circumstances, then yes, you may be required to sort of to ask to ask people to sort of hand over anything that may fall within the scope of the request.
On that question then, what constitutes data in terms of communication records? If we take, for example, WhatsApp, would this include, if they are relevant to personal data, reactions to messages in addition to the actual content of the messages themselves?
Again, that's a really good question. I once asked the team here, did they think that an emoji was personal data? And it really depends on the circumstances, and I think yes, quite possibly. But if but remember, the obligation though is just to disclose the personal data rather than sort of everything. So if somebody says she made me really angry, and then there's sort of an anger emoji, you wouldn't disclose the emoji because you've already disclosed the fact that this person made them angry. So it really depends on the circumstances, but potentially yes.
Thank you. We've just got time for a couple more questions, I think, slightly running over 2 p.m, but Andrew's kindly staying on the call. If anyone else has any further questions, please do paste them into the Q&A box. Otherwise, Andrew, what is the appropriate limit, or sorry, is it appropriate to limit or exclude liability in a contract between a data controller and a processor under Article 28 or in another form of data sharing contract?
If you are acting for the controller, then clearly you wouldn't want to sort of be you would be looking to exclude the processor's liability. So I guess it depends sort of which side of the fence you are sitting on. There is I think it's Article 81 or 89 of the GDPR says that anyone can claim, any person can claim damage for a breach of the GDPR. And it's interesting, it says person rather than individual, because the wording used in the Data Protection Act was individual. So there's an implication that corporations can claim damages for data breaches. So if you've lost a business opportunity because the other parties breached data protection law, which then leads on to another question, is it actually lawful to limit data protection liability in contracts? And it's not something that's sort of received any sort of judicial scrutiny. On my, if we just for context, if we look at the EU SCCs, I think they make it. I think arguably the position in those is that the controllers, the import exporter can't limit liability, but the ICO through the IDTA seems to suggest otherwise. So it seems to just by implication that contracting parties can actually limit liability, notwithstanding to each other. You come to data subjects, notwithstanding the wording in the GDPR.
Thank you very much indeed. There's nothing more coming in. So on behalf of everyone who's able to join us today, and those people in the future watching us on the catch-up, thank you very much indeed, Andrew Gallie, for speaking to us today. Oh, I'll tell you what, no, if you've got time for one more question, there's a late one just come in. If you send an email to multiple recipients on Microsoft Outlook, and all the recipients' email addresses are in the BCC, but the email is not sent securely, would this be considered a data breach?
So it is not a personal data breach, but it is a breach of the data protection principles. And so there was a case about a year ago involving a charity in Scotland where this is what they did. Their practice of that mailing list was to put the email addresses in the BCC field, but they didn't do that. But the ICO made it very clear that if your practice is to use BCC, that's not enough because it is too easy to make a mistake. So by doing so, you're breaching the data protection principles, even if it's not a personal data breach, because the recipients didn't actually receive information that they weren't entitled to see. So I would if you're sending out sort of mailing lists and that sort of thing, I would suggest that you get software that can fire out stuff securely without sort of the need to have to rely on BCC.
Thank you very much indeed. So I think that's bringing us to a reasonably timely conclusion. Thanks so much again, Andrew. For those of you who joined us late, our next lunchtime webinar is in a fortnight. That's the 8th of February on e-scooters, 2 wheels good or 2 wheels bad. An update from Patrick West at St John's Chambers at the slightly earlier time of 12:30 p.m. Details and a link to sign up, along with details of other upcoming events, are all available on Bristol Law Society's shiny new website at www.bristollawsociety.com, along with lots of other information and news about upcoming events and the Society. So if you haven't had a look at the new website, please do. Thanks very much, everyone, for joining us today.